Welcome back to the Deep Dive, where we take complex ideas and give you the ultimate shortcut to being truly well-informed. Today, we're embarking on a fascinating and I think incredibly relevant journey into the very essence of individual liberty and, well, human dignity enshrined within India's constitution, specifically Articles 22 through 28. These aren't just, dry legal texts. They are the living principles that define freedom, equality, and justice for over a billion people. And they're constantly being shaped by, well, a vibrant democracy and a vigilant judiciary.
Indeed. And we've compiled quite a stack of sources for this deep dive: landmark Supreme Court judgments, academic analyses, insightful commentaries on India's constitutional framework. Our mission today is really to unpack these crucial articles, understand their nuances, and discover how they not only safeguard individuals from arbitrary state power, but also, crucially, protect against various forms of exploitation and guarantee religious freedoms. You'll gain, hopefully, a clear understanding of not just what these rights are, but why they matter, how they've evolved through judicial interpretations, and importantly, the enduring challenges in their application.
Okay, let's dive in then, Allie. The Shield of Liberty.
Right.
Protection against arrest and detention. Article 22.
Right, so Article 22. What's truly profound about it isn't just the safeguards themselves, but the sheer boldness, you could say, of an independent nation choosing to codify preventive detention, a tool often linked with, well, authoritarianism within its fundamental rights.
That's an interesting tension right there.
It is. The deep insight here is recognizing this inherent tension and how the judiciary has spent decades trying to sort of put legislative chains on executive power, trying to turn what could be a weapon into a carefully monitored scalpel, if you like.
Okay.
It reflects a uniquely Indian negotiation between state necessity and individual freedom, establishing these vital procedural safeguards against arbitrary arrest and detention.
That's a powerful framing right from the start. So, at its core, Article 22 addresses two very distinct scenarios. You mentioned punitive detention.
Yes, where someone is held after a conviction for a crime.
Right. And then there's preventive detention.
Which is detention without trial, based on suspicion, really, to prevent future wrongdoing.
Let's unpack this crucial distinction then. So it's about making sure the state doesn't just, well, scoop you up without reason in either scenario. Is that the basic idea?
Precisely. When someone is arrested for a crime, what we term punitive detention, where you're held for an alleged offense, the Constitution immediately provides these two non-negotiable shields. These are outlined in the initial clauses of Article 22, clauses 1 and 2, and they're considered absolute fundamental rights in those situations. A, safeguards for ordinary arrests, clauses 1 and 2, your basic rights. So the very first safeguard, right there in Clause 1, is your right to be informed of the grounds of your arrest as soon as may be.
As soon as may be.
Yes. And this isn't just a suggestion, it's a constitutional mandate. It's about ensuring transparency and preventing arbitrary action right from the moment of arrest.
And that phrase, as soon as may be, it isn't just legal jargon, is it? It feels like the critical first line of defense against, someone just disappearing into the system.
Absolutely. And the courts have been really quite unwavering in interpreting it as an urgent, non-negotiable obligation. It means with reasonable expedition, not just whenever the authority feels like getting around to it.
Right.
The arrested person shouldn't be left guessing or held in the dark about why their liberty has been curtailed. A significant delay, if there's no strong justification, can actually invalidate the arrest itself.
Right.
Which underscores the judiciary's commitment to immediate transparency. For you, the individual, this means you immediately know what you're being accused of, allowing you to start preparing your response or defense. Following immediately from that is another indispensable protection: the right to legal counsel.
Okay, the lawyer.
Yes. Clause 1 explicitly states you have the fundamental right to consult and be defended by a legal practitioner of your choice. Your choice. This right cannot be denied.
That sounds powerful.
It is. It's a powerful shield, ensuring you have access to legal expertise right from the outset, allowing for informed decisions and a proper defense. It's not just about having a lawyer present during interrogation, but the right to choose your legal representation and, crucially, to consult with them privately.
This is where it gets really interesting for me, because later court decisions, they connect this right to the right to free legal aid, right? For people who can't afford a lawyer.
Exactly. That's a crucial development.
The Supreme Court recognized that just saying you have a right to a lawyer isn't enough if you're poor.
Precisely. To make this right meaningful for everyone, not just those who are privileged, the courts interpreted it to include free legal aid for those who are unable to pay.
Making it a truly universal right in practice.
Yes, it's a vital expansion linking Article 22.1 directly to the broader right to life and personal liberty under Article 21 and also to directive principles like Article 39A, which calls for equal justice and free legal aid.
So it stops economic status being a barrier.
Exactly. It ensures that economic status doesn't become a barrier to accessing a fundamental constitutional protection.
That's a huge expansion. So it's not just a right for the privileged, but a right for all.
Yeah.
What happens after you've been informed and hopefully consulted a lawyer? What's the next critical step?
The next crucial safeguard comes in Clause 2. That's the right to be produced before the nearest magistrate within 24 hours of arrest.
24 hours.
Yes, and this period specifically excludes the time needed for the journey from the place of arrest to the court.
Okay, practical point.
And just as importantly, Clause 2 also says no such person shall be detained in custody beyond that 24-hour period without specific authorization from a magistrate.
Why exactly 24 hours? What's the significance of that specific time limit for you, the individual, and for the broader system?
Well, the 24-hour limit is a critical check on executive, meaning police, power. Its significance for you, the individual, is immense. It prevents prolonged police custody without any judicial oversight.
So a judge gets involved quickly.
Yes. The magistrate is an independent judicial authority. They review the legality of your arrest, make sure you've been informed of the grounds, check that your rights are being respected, and most importantly, prevent the police from holding you indefinitely or potentially extracting confessions under duress. It's a swift, mandatory judicial review. It prevents illegal detention right from the start and puts a hard stop on the potential for arbitrary police action.
Can you give us an example?
Sure. Imagine A is arrested for alleged theft. The police's immediate obligations are crystal clear. Inform A of the reason, allow legal counsel, and bring A before a magistrate within 24 hours. If they fail to do any of that,
The detention becomes illegal.
correct. The detention becomes illegal, and A can seek release through a writ of habeas corpus. B, exceptions to basic safeguards, Clause 3.
That truly sounds like a shield. Now, are there any situations where these basic crucial safeguards, being informed, getting a lawyer, seeing a magistrate in 24 hours, don't apply?
Yes, there are specific exceptions outlined in Clause 3 of Article 22. Understanding these is key to grasping the full scope. First, these safeguards don't apply to what are termed enemy aliens.
Okay, so if you're a citizen of a country India is actively at war with, those immediate protections would be different.
Precisely. If, for instance, a citizen of a country with which India is at war is arrested, they wouldn't automatically get the same immediate protections under Article 22(1) and 2 as an ordinary citizen or even a friendly alien.
The rationale being national security, I assume.
Yes, prioritizing state defense during active hostilities. The second and far more complex exception is for persons arrested or detained under laws specifically designed for preventive detention.
Back to preventive detention.
Yes. These are a different class of detention entirely. It's not for punishment after an offense, but for preventing an anticipated threat to public order or national security. See safeguards for preventive detention, Clauses 4 to 7. A necessary evil, carefully monitored.
So if you're arrested under a preventive detention law, those immediate 24-hour rules don't apply. But surely there must be some safeguards, right? It sounds incredibly powerful detention without trial based on suspicion. That concept sits uneasily with democratic principles. How does the Constitution reconcile that?
You've absolutely hit on the core tension there. The Constitution recognizes the serious nature of preventive detention. It acknowledges it as a kind of necessary evil in specific, very particular, urgent circumstances where immediate action is deemed vital for state security or public order.
But deeply invasive of personal liberty at the same time.
Deeply invasive, which is precisely why Clauses 4 through 7 of Article 22 establish a separate, though still stringent, set of safeguards. These are designed to carefully monitor this extraordinary power.
Okay, so what are they?
Generally, detention under preventative laws cannot exceed 3 months unless an advisory board finds sufficient cause for a longer detention.
Advisory board.
Yes. And this board must consist of persons qualified to be high court judges.
That sounds like a significant check. 3 months isn't arbitrary, and there's a judicial level review involved. That introduces an element of sort of quasi-judicial oversight.
Exactly. It's an attempt to balance state security with individual liberty by bringing in this quasi-judicial oversight mechanism. It's an acknowledgement that while preventative detention is seen as necessary sometimes, it must be carefully monitored by independent minds. And it's worth noting, the 44th Amendment Act back in 1978 even aimed to tighten this further, reducing the initial period to 2 months and changing the board's composition slightly, though. The notification status of those specific changes is a bit complex. But the spirit was clear. Tighten the reins.
So even in such a sensitive area, there's this underlying drive for greater individual protection. What other safeguards exist for someone under preventive detention? Do you still have a right to know why you're being held?
Yes, absolutely. That's fundamental. Clause 5 mandates that the detaining authority must communicate the grounds of detention to the detainee as soon as may be. Again, that phrase.
And can you challenge it?
Yes. Critically, you must be given the earliest opportunity to make a representation against the detention order. This is a fundamental procedural right. It ensures that even if you're detained without trial, you're not just held incommunicado, in a vacuum.
So even in these cases, you still have a right to know why you're being held and to present your side to challenge the very basis of your detention.
Yeah, precisely. This is fundamental to the principle of audi alteram partem. Hear the other side, even in a preventive context. Now, Clause 6 does allow for non-disclosure of certain facts if they are considered against the public interest to disclose. But, and this is absolutely crucial, this does not mean the grounds of detention themselves can be withheld.
The reasons versus the specific detail.
Exactly. You must know the basis, the reasons for your detention to make an effective representation. Specific sensitive details might be withheld, but the core reasons cannot be kept secret. Lastly, Clause 7 specifies that Parliament can legislate on the circumstances for detention beyond 3 months, subject to a prescribed maximum period, and also the procedure for these advisory boards.
So the legislature sets the framework.
Yes, but the constitutional safeguards remain the bedrock. To illustrate this, imagine B is detained under a preventive detention law, say, for national security concerns. B must still be told the grounds unless specific facts are against public interest, but not the overall reasons. B must be allowed to make a representation, and any detention beyond 3 months typically requires that advisory board approval.
So the system aims to prevent executive overreach, even in serious situations.
That's the objective, yes. D. Deeper dive. Analysis, judicial role, and key phrases.
That offers a much clearer picture of the dual protections. So to really dive deep into Article 22, it's about providing safeguards for both ordinary arrests, punitive and preventative detention, but with different protections recognizing their distinct natures. What's the core object, then, the main goal of all these provisions?
At its heart, Article 22 is designed to stop the executive, the government or police, from just arbitrarily picking people up. The primary object is to prevent arbitrary executive action and ensure procedural fairness, especially when personal liberty is so seriously invaded by detention without trial.
It's a bulwark against state power, essentially.
It is. And while the Constitution, somewhat uniquely among democracies, recognizes the power of preventative detention, allowing it in the interests of state security and public order, it acknowledges its serious, harsh nature and simultaneously seeks to mitigate that harshness with these built-in safeguards.
It's an uneasy compromise, you could say.
An uneasy but constitutionally recognized compromise, yes.
It sounds like the courts play an incredibly significant, absolutely crucial role here, given the stakes for individual liberty.
They do. It's paramount. Courts act as the crucial guardians of liberty, interpreting these safeguards strictly. They don't just rubber stamp executive decisions.
How strictly?
Well, they can examine the relevance of detention grounds, they ensure procedural compliance meticulously, and they can review the subjective satisfaction of the detaining authority, though to a limited extent.
What does that mean, subjective satisfaction?
It means checking if the decision was made in bad faith malafides or if there was a non-application of mind, meaning the authority didn't genuinely consider the facts before ordering detention. And that phrase we keep coming back to, as soon as may be, has been judicially interpreted again and again to underline the need for reasonable speed, reasonable expedition in informing the person of the grounds, emphasizing urgency over convenience.
And linking back to what you said earlier about legal aid, this has become a broader right, hasn't it? Going beyond just a letter of the law.
Absolutely. The right to a legal practitioner through judicial interpretation has expanded to include free legal aid for those who can't afford it.
The indigent.
Yes. This is a vital connection. It shows how fundamental rights are interconnected and how judicial interpretation ensures that a right on paper translates into a right in practice, making it truly accessible, especially for you, the individual, who might not have the means otherwise. Without this, the right to counsel would be, frankly, meaningless for a vast segment of the population. Landmark case law, shaping the interpretation.
So many of these concepts, these interpretations, have been shaped by landmark court cases over the decades. Can you walk us through some of the most influential ones, maybe starting with an early foundational case that kind of set the stage?
Certainly. One of the earliest and most foundational cases, which actually took a rather narrow view initially, was A.K. Gopalan versus State of Madras back in 1950.
Right at the beginning of the Republic.
Yeah. Exactly. This case was pivotal because it tested the brand new Constitution's provisions on liberty. Gopalan, a communist leader, was detained under a preventative detention law. His lawyers argued that the procedure for detention must follow due process, meaning it had to be just, fair, and reasonable, drawing inspiration from the U.S. system.
And what did the Supreme Court decide? What was its reasoning, especially concerning that key phrase, procedure established by law in Article 21?
Well, the Supreme Court took a very literal, very precise, and some would definitely say restrictive view of procedure established by law under Article 21.
How so?
Essentially, they ruled that if Parliament had passed a law, even if that law seemed harsh or maybe unfair, and that law laid down a procedure, then the courts wouldn't question the fairness or reasonableness of the law itself. They would only check if the procedure laid down in that specific law was strictly followed.
So different from the American due process idea.
Very different. The U.S. due process allows courts to evaluate if a law is inherently just, fair, and reasonable. Gopalan's interpretation meant the scope of liberty under Article 21 was initially quite narrow. It was a kind of legal tightrope act that would be dramatically reevaluated decades later, but it set the early precedent that Article 22 was essentially a self-contained code dealing with detention.
Okay, so that was the starting point. How did that understanding evolve, particularly for ordinary non-preventive arrests?
Well, the courts began to emphasize the practical application of these rights more over time. In State of Madhya Pradesh versus Shoharam, 1966, the court stressed that the grounds of arrest given under Article 22 must be sufficient. Sufficient for the arrested person to actually understand why they've been arrested and to adequately prepare a defense.
So not just a vague reason.
Exactly. It's not enough to just give a vague reason like antisocial activities. The information must be clear, precise, and enable a meaningful response. This directly impacts your ability as the arrested person to defend yourself effectively.
That makes sense. What about that critical aspect of legal aid we discussed? Making sure the right to a lawyer isn't just for the wealthy. When was that cemented?
That was definitively established in Khatri II versus State of Bihar, 1981. This is famously known as the Bhagalpur blinding case.
Oh, yes. A horrific case.
Truly horrific. It involved police blinding under trial prisoners. The Supreme Court was understandably appalled and, in a landmark judgment, held that the right to free legal aid at state cost is a fundamental right of an indigent accused person.
Implicit in the right to life.
Yes, implicit in Article 21, the right to life and personal liberty, and absolutely essential for making the right to consult a lawyer under Article 22(1) truly meaningful and effective for everyone, not just a theoretical right for some. This case had a profound, transformative impact on legal aid services across India.
And to prevent police abuse more broadly, I recall there were specific, very detailed guidelines laid down later to protect people who were arrested.
Yes, a really monumental step was taken in D.K. Basu versus State of West Bengal in 1997. To prevent the abuse of power by police during arrest and detention, the Supreme Court laid down detailed, mandatory guidelines that police authorities must follow.
What kind of guidelines?
Things like informing a friend or relative of the arrest promptly, recording the arrest accurately in a memo of arrest, which should be witnessed by a family member or a respected local person, ensuring an immediate medical examination of the arrestee, and explicitly ensuring that legal aid is offered.
So practical steps?
Very practical. These guidelines reinforce the safeguards in Article 22 and strongly link them to human dignity under Article 21. They are procedural safeguards designed specifically to protect you against mistreatment and ensure accountability.
Turning now to preventive detention again, how do the courts weigh in on something as significant as the National Security Act, given its, well, extraordinary powers?
In A.K. Roy versus Union of India, 1982, which specifically examined the National Security Act, or NSA, the Supreme Court upheld the constitutional validity of the act. But crucially, it read several important safeguards into its application.
Such as?
It held that while certain specific facts need not be disclosed if deemed against the public interest under Article 22.6, this absolutely does not mean the grounds of detention themselves can be vague, irrelevant, or non-existent. The denu, the person detained, has an undeniable right to make an effective representation against their detention.
So even in sensitive national security cases, the right to challenge remains strong.
Yes. The court ensured that the individual's right to challenge the detention remained robust, preventing arbitrary blanket detentions based on flimsy reasons.
What if there are multiple reasons given for detention, and maybe one of them turns out to be flawed or vague? Does that affect the whole detention?
That's a great question, and yes, it absolutely can. In Shibunlal Saxena versus State of UP, way back in 1954, the court held that if even one of several grounds of detention is found to be vague or irrelevant or non-existent, the entire detention order is vitiated, it's invalid.
The whole order. Why?
Because it's impossible for the court, or indeed the date to determine to what extent that single bad ground operated on the mind of the detaining authority when they made the decision. So the entire basis of the detention becomes suspect.
That's a very powerful protection for the individual, ensuring the authorities have to be really careful and accurate.
It is. It ensures that detaining authorities are meticulous and accurate in their reasons, or the whole detention can fail. F legal maxims and theories.
But that's a comprehensive look at how the courts have shaped Article 22. What core legal maxims or theories really underpin these protections, making them so vital in a constitutional democracy?
Well, fundamentally, we see audi alterum partem.
The principle of hear the other side.
Exactly. It's implicit in Article 22.1 with the right to be defended, and in Article 22.5 with the right to make a representation against preventive detention. It's about fairness.
And the rule of law.
Absolutely. These safeguards are essential components of the rule of law. They ensure that executive power, state power, is exercised within the bounds of law and fairness rather than based on arbitrary whim or fiat.
And that balance we talked about.
Yes, ultimately, these provisions reflect that inherent tension and the constitutional effort to balance individual freedom with state and public security. It's a delicate and continuous act of balancing. Article 22 attempts to mitigate the inherent harshness of detention, especially preventive detention, by embedding these crucial procedural checks. It's a recognition, really, that while state power is necessary, it must never, ever be unchecked. Upholding human dignity, the right against exploitation, Articles 23 and 24.
That deep dive into Article 22 truly reveals the intricate legal architecture built to safeguard us from, arguably, the state's most formidable power, the power to detain. But liberty, for you and me, isn't just about protection from wrongful arrest. It's fundamentally about living with inherent dignity, free from exploitation by anyone. And it's this crucial aspect of human dignity that Articles 23 and 24 champion. They shift our focus, maybe, from the police station to the everyday struggles for justice in our society. Article 23, prohibition of human trafficking and forced labor.
Absolutely. Article 23 is a powerful, unequivocal statement against practices that treat human beings as commodities, rather than as individuals with inherent worth and dignity. It protects individual dignity and freedom by absolutely prohibiting human trafficking, big R, and all other forms of forced labor.
It makes it explicit these aren't just morally wrong, they're constitutionally outlawed.
Yes, and legally punishable offenses.
Okay, let's break down those basic ingredients.
Yeah.
What does traffic in human beings really cover, beyond the obvious image of slavery?
Well, traffic in human beings is intentionally broad and comprehensive. It certainly covers the buying and selling of people as commodities, which is, abhorrent to human dignity. But it also includes the immoral trafficking of women and children for purposes like prostitution, forced marriage, or domestic servitude. Even things like organ trafficking fall under this.
So any involuntary movement or trade of people for exploitation.
Exactly. For instance, running a racket to traffic women for prostitution directly violates Article 23.1, and it's punishable under specific laws Parliament enacted, like the Immoral Traffic Prevention Act.
And what about begar? It sounds like an older term, maybe something from feudal times.
It is indeed. Begar refers to a specific historical form of forced labor without remuneration. It was a legacy of feudal practices where individuals, often from vulnerable communities, were compelled to work for no pay, or perhaps for symbolic amounts, for landlords or local authorities. The Constitution explicitly outlaws this dehumanizing practice.
And then there's the catch-all phrase.
Other similar forms of forced labor. Yes, this is crucial because it covers all involuntary servitude, whether it's paid or not, regardless of the form it takes. It definitely includes bonded labor. And, as courts have expansively interpreted it, it even includes work for less than the minimum wage if that work arises from economic coercion.
So to take an illustrative scenario, a landlord forcing vulnerable, perhaps landless laborers to work for no wages, or maybe nominal wages far below the legal minimum. That clearly falls under forced labor, even if there's some pretense of an agreement.
Exactly. The courts have been very clear on this. Any contravention of these prohibitions isn't just a civil wrong, it's an offense punishable in accordance with law. And Parliament, as mentioned, has enacted significant legislation like the Immoral Traffic Prevention Act of 1956 and, very importantly, the Bonded Labor System Abolition Act of 1976 to give practical teeth to this constitutional provision. It shows the state's commitment to eradicating these practices.
Are there any situations where compulsory service is permissible? For instance, if the state itself requires some form of public service in an emergency.
Yes, Clause 2 provides a carefully carved-out exception. The state can impose compulsory service, but only for public purposes.
Gotcha.
Things like military service or maybe social service during major calamities like floods or earthquakes. For instance, a law requiring citizens to render essential services during a national emergency, like a war or a natural disaster, is constitutionally permissible.
But there's a catch.
A vital one. It's crucial that this compulsory service cannot discriminate on grounds only of religion, race, caste, or class. It must be for genuinely public, non-discriminatory purposes. So, analyzing Article 23, the paramount objective is clearly protecting human dignity and preventing the exploitation of vulnerable individuals. That much seems crystal clear.
Absolutely. And a key point here, one that's often missed by people who view fundamental rights as solely operating against state action, is that this article, Article 23, is enforceable not just against the state, but also directly against private individuals.
That's significant.
It is. The prohibition under Article 23(1) applies to anyone who engages in these exploitative practices, whether they are individuals, landlords, employers, companies, or even criminal syndicates.
So this isn't just about what the state can or can't do, but about protecting you from exploitation by anyone, even another person or a company. Wow, here's where it gets really interesting, taking constitutional protection directly into everyday social and economic interactions.
Exactly. The Supreme Court has unequivocally stated that Article 23 is enforceable against private individuals. And moreover, the state has a positive constitutional obligation to enact laws and take proactive steps to protect this right from infringement by private actors.
That dramatically expands its scope, makes it a powerful tool for social justice.
Immensely powerful. Furthermore, as we touch upon, courts have expanded the definition of force beyond just physical or legal coercion. They've included compulsion arising from economic circumstances, things like poverty, hunger, or destitution.
That's revolutionary, isn't it?
It really is. This interpretation means that even working for less than the minimum wage, if you're driven to it by economic necessity, can be considered forced labor under Article 23. It directly links the constitutional right to the protection of human dignity in the economic sphere.
And it connects to other rights, too.
Yes, this right is closely intertwined with other fundamental rights. Equality under Articles 14 and 15, and the right to life and personal liberty under Article 21. Exploitation fundamentally infringes upon these core rights. It dehumanizes the individual. Landmark case law.
That's a strong and expansive interpretation. I imagine there are landmark cases that particularly shape this understanding of economic compulsion as a form of forced labor.
There are, and they are truly groundbreaking. People's Union for Democratic Rights versus Union of India, 1982, famously known as the Asian Workers case, was a landmark ruling.
Related to the Asian Games in Delhi.
Yes. The case emerged from the exploitation of construction workers hired for the 1982 Asian Games, who were being paid less than the statutory minimum wage. The Supreme Court, responding to a public interest litigation, defined force to include economic compulsion. It unequivocally established that payment below minimum wage constitutes forced labor under Article 23, and crucially, that this is enforceable against private individuals, the contractors in this case.
What was the core reasoning?
The court effectively said just because someone is desperate due to poverty, that doesn't make their consent to work for less than minimum wage legitimate or truly voluntary. That's a powerful moral and legal stance.
So even if someone technically agrees to work for less because they're destitute, it's still considered forced. That really shifts the burden towards ensuring fair conditions.
Yes, it fundamentally reframes the idea of consent when faced with extreme poverty or destitution. This principle was reiterated very clearly in Sanjit Roy versus State of Rajasthan, 1983.
What happened there?
In that case, the court held that even famine relief work intended to alleviate distress, could not justify paying less than minimum wage. The plea that the work is for famine relief doesn't excuse exploitation. The state has an obligation to ensure fair wages even in such circumstances.
Wow.
And then, Bandhua Mukti Morcha versus Union of India, 1984, dealt extensively with the pervasive, deeply entrenched issue of bonded labor.
A huge problem in India for a long time.
A massive problem. The Supreme Court gave sweeping directions for the identification, release, and rehabilitation of bonded laborers, squarely placing it under the umbrella of forced labor prohibited by Article 23. And importantly, it imposed a proactive duty on the state to find and help these individuals. This case really highlighted the immense scale of the problem and the judiciary's commitment to its eradication, legal maxims and theories.
In essence, Article 23 is fundamentally about the right to human dignity, and it's clearly a critical provision for achieving social justice.
Absolutely. The right to human dignity is the core underlying principle. It views every individual as an end in themselves, never merely a means to an end, and its expansive interpretation by the courts makes it a central pillar of social justice, actively seeking to rectify historical imbalances and protect the vulnerable from economic and social exploitation, ensuring, or at least striving for, a more equitable society. B. Article 24, Prohibition of Employment of Children in Hazardous Work. Moving on from the general prohibition on forced labor, Article 24 is another crucial facet of the right against exploitation. This one focuses specifically on our most vulnerable population, children.
Okay.
Article 24 is a specific, absolute prohibition. It protects children under the age of 14 from exploitation and hazardous employment. It recognizes their unique vulnerability and the absolute need for special, non-negotiable protection. It's about safeguarding their future, their health, and their right to childhood.
So the text says, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. That sounds very clear, very direct, leaves little room for ambiguity.
It is remarkably clear. The basic ingredients are straightforward. The age limit is strictly no child below the age of 14 years. The phrase shall be employed to work signifies an absolute ban, a complete constitutional prohibition for this age group in the specified areas.
And those areas are?
Specifically mentioned are factories and mines. But then there's the broader and really crucial category, any other hazardous employment.
Right. How do we define hazardous employment, though, especially in a way that remains relevant as technology changes, new industries pop up? Is it static list, or does the interpretation adapt?
That's a very perceptive and crucial question. The Constitution deliberately doesn't provide an exhaustive list of jobs, precisely because it recognized that what constitutes hazardous can change over time.
Makes sense.
Instead, the term hazardous employment isn't defined in the Constitution itself. Rather, it's left to be interpreted by legislation and, critically, by the courts. This allows its definition to evolve and adapt to new industrial processes and societal realities.
Can you give examples?
Sure. A 12-year-old working on a dangerous factory machine, that's a direct, clear violation. Children under 14 working in a coal mine, unequivocally prohibited. A 13-year-old handling corrosive chemicals in a factory, undeniably hazardous.
But it goes beyond the obvious, heavy industries.
Yes. The courts have broadened it further over time. Even certain types of domestic work, depending on the specific conditions, long hours, dangerous tasks, abusive environments, have come under scrutiny as potentially hazardous. This has led to legislative and judicial interventions aimed at protecting children from a much wider array of exploitative situations. So the living protection constantly being refined and expanded. So this isn't static. It's a living protection adapting to new forms of exploitation. What's the core analysis here? What are the key takeaways from Article 24?
Well, the primary object is the holistic protection of children, their health, their well-being, their education, and their overall development. The prohibition is absolute for the specified employments for children under 14. That means there are no exceptions, no loopholes for children in this age group within those sectors.
And this article has led to actual laws being passed.
Yes, it's been a significant legislative mandate. It spurred vital laws like the Child Labor Prohibition and Regulation Act of 1986. And that act itself has since been amended quite substantially to cover both children and adolescents more comprehensively, broadening the scope of protection significantly.
And there's a link to education, too, isn't there?
A very important link. Article 24 directly complements Article 21A, which guarantees the right to education. By prohibiting child labor, especially in hazardous jobs, it creates an essential environment where children can actually attend school instead of being forced into work. It helps make the right to education a reality, not just an aspiration, and ensures children have a chance at a full childhood. Landmark case law.
Which landmark cases really drove the enforcement of this absolute prohibition and maybe pushed the state to take more proactive steps against child labor?
One of the most significant was People's Union for Civil Liberties versus Union of India, 1997. This dealt specifically with the appalling conditions of child labor in the Sivakasi match factories in Tamil Nadu.
Infamous for child labor.
Yes. The Supreme Court gave extensive, detailed directions for eradicating child labor in these hazardous industries. It strongly emphasized the state's responsibility not just to ban it, but to actively identify such children, ensure their release, and crucially, provide for their rehabilitation and education.
I recall another major case, maybe even broader, that issued wide-ranging directions for abolishing child labor across different industries.
You're likely thinking of MC Mehta versus State of Tamil Nadu, 1996, often called the child labor abolition case. Here, the Supreme Court issued wide-ranging, comprehensive directions aimed at eliminating child labor, not just in specific factories like Sibakasi, but across various industries nationwide.
What kind of directions?
They included provisions for compensation to be paid by offending employers, the creation of a specific child labor rehabilitation cum welfare fund to support rescued children, and a clear mandate for their education and rehabilitation. The court stressed that Article 24 is a constitutional mandate, not merely an advisory principle. It imposes a proactive, positive obligation on the state to act.
So the state can't just sit back.
No. And earlier, the Bandua Mukti Morsha versus Union of India 1984 case, while primarily dealing with bonded labor, also significantly addressed child labor within that broader context of exploitation. It again highlighted the state's constitutional obligation to protect children from such practices, legal maxims and theories.
It sounds like the legal theories behind Article 24 are deeply rooted in the concept of the state acting as a guardian, a protector for its most vulnerable citizens, the children.
Indeed. It's strongly grounded in the parens patriae doctrine, meaning the state acts as a parent or guardian to protect the interests of those who cannot protect themselves, like children. This doctrine, along with the internationally recognized principle, the best interests of the child, is paramount here. Article 24 directly serves this principle by safeguarding children from harmful labor and ensuring their well-being, education, and development are prioritized above economic considerations. It's really a testament to the idea that, well, a society is judged by how it treats its children. 3. The fabric of faith, right to freedom of religion, Articles 25 and 26.
That journey through Articles 23 and 24 really underscores the Constitution's profound commitment to human dignity, from economic freedom to the fundamental protection of childhood. Now we shift gears a bit, turning to a deeply personal and often collective aspect of human existence, the freedom of religion. This is a topic I think that can often be misunderstood, and India's approach, often termed positive secularism, is genuinely unique, isn't it? For someone who understands the basic tenets of religious freedom, what's the key difference with this Indian model, and how does Article 25 really embody that approach? Article 25, freedom of conscience and free profession, practice, and propagation.
That's a perfect lead-in. Article 25 guarantees individual freedom of religion to all persons. That's the first key point, all persons, not just citizens. It encompasses both the absolute inner belief, your individual relationship with the divine, or lack thereof, and the outward expression of that faith.
So belief in action.
Yes. This includes the right to profess, practice, and even propagate your religion. But crucially, and this is where India's distinct positive secularism really shows itself, it's not an absolute right.
The limitations.
Exactly. It comes with important limitations that are designed to balance individual religious freedom with broader societal concerns like public order, health, morality, and, very importantly, other fundamental rights guaranteed in the Constitution.
So, unlike maybe some Western models that emphasize a strict separation of church and state.
Right. India's state maintains what's often called a principled distance. It treats all religions equally. It doesn't have a state religion, but it can intervene for social good, for social reform, even if that touches upon religious practices. It's not strictly hands-off.
Okay, so all persons means citizens and non-citizens, and equally entitled emphasizes universal access. What are the four specific facets of this individual religious freedom that are guaranteed? And what do they truly mean in practice for you, the individual?
Clause 1 outlines them clearly. First, there's the freedom of conscience. This is the absolute, unfettered inner freedom, the freedom to mold one's own relationship with the divine or with spirituality, or to hold no belief at all. It's the most private, internal aspect of religious freedom.
Untouchable by the state.
Absolutely. Second, the right to profess,
Right.
which is simply the freedom to openly declare one's religious beliefs and faith, to say, this is what I believe. Third, the right to practice. This is broader. It encompasses the freedom to perform religious duties, rites, ceremonies, modes of worship, and observe the tenets and customs of your faith. So, for instance, an individual performing a religious ritual at home or observing specific dietary restrictions mandated by their faith that's protected under the right to practice.
Okay, and the fourth facet is the right to propagate. Now, this one can be controversial. Does that mean you have the right to try and convert people? Or does it have specific boundaries, especially in a diverse, multi-religious society like India?
That's a critical question. The right to propagate is the freedom to communicate or spread one's religious beliefs to others. So a religious group peacefully distributing pamphlets explaining their faith or engaging in public discourse, maybe missionary work explaining their beliefs, that is protected. But, and this is where the nuances of Indian secularism and the need for communal harmony come into sharp focus crucially, this does not include the right to convert another person by force, fraud, or allurement.
Force, fraud, or allurement. Okay.
Yes, the right is to share, to explain, to persuade through genuine conviction and exposition of tenets. It is not a right to compel, deceive, or bribe someone into changing their faith. That distinction is absolutely vital for maintaining religious freedom for all and preventing conflict.
That's a vital distinction, preventing the misuse of the right to propagate. And you mentioned these rights are not absolute. What are the key limitations, again, the ones that balance individual faith with broader societal interests?
Right. These freedoms under Article 25(1) are explicitly subject to three major limitations mentioned right at the start: public order, morality, and health.
So give me an example.
Okay. So, for instance, a very loud religious ritual conducted throughout the night causing significant public nuisance could potentially be restricted on the grounds of public order. A practice deemed fundamentally immoral by prevailing constitutional standards, or one that poses a serious threat to public health, could also be curtailed.
And it's also subject to other fundamental rights.
Yes, crucially, they are also subject to the other provisions of this part, meaning the other fundamental rights in Part 3 of the Constitution. This is hugely important. It means your right to practice your religion cannot infringe on someone else's fundamental rights, like their right to equality, Article 14, their right not to be discriminated against, Article 15, or their right to life and dignity, Article 21. It sets up a framework for resolving conflicts between rights, states' power to regulate and restrict, Clause 2. Beyond those general limitations, the state also has significant power to regulate and restrict certain activities under Clause 2. This really reflects India's unique secular model.
How so?
Specifically, Clause 2A allows the state to regulate or restrict any economic, financial, political, or other secular activity which may be associated with religious practice.
Secular activities associated with religion.
Exactly. This is key because it allows the state to distinguish between what are considered essential religious practices, those truly integral to the faith, and other appended secular activities, which can be managed for efficiency, transparency, or public interest.
Like managing temple finances.
Precisely. A state law managing the financial administration of a large temple trust to prevent mismanagement or ensure proper accounting is perfectly permissible under this clause. It deals with the secular aspect of financial administration, not the core religious beliefs or rituals themselves.
And what about social welfare and reform? Can the state intervene in religious practices if it believes it's for the greater good of society?
Yes, unequivocally. Clause 2B empowers the state to make laws providing for social welfare and reform. This power exists even if those laws affect or interfere with religious practices.
That's quite a strong power.
It has been historically very significant in India. Think of laws abolishing practices like sati or prohibiting child marriage or more recent legislative actions related to practices like triple talaq. A law prohibiting the Devadasi system, for example, where young girls were dedicated to temples and often ended up exploited, would be a valid social reform measure under this clause.
And Clause 2B also mentions opening Hindu institutions.
Yes, it specifically allows the state to make laws for the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. This was aimed squarely at addressing historical caste-based discrimination and exclusion from temples and other public religious places within the Hindu community. Explanations A and 2. And just to be complete, there are two specific explanations attached to Article 25. Explanation I explicitly clarifies that the wearing and carrying of kirpans is deemed to be included in the profession of the Sikh religion. It recognizes it as an essential religious practice for Sikhs.
Okay.
And Explanation 2 provides a definition. It states that for the purposes of subclause B of Clause 2, the social reform and opening of institutions, part the reference to Hindus, shall be construed as including persons professing the Sikh, Jaina, or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. It essentially broadens the scope of that specific provision. So pulling this all together, the analysis of Article 25 clearly shows its primary focus is on individual freedom of religion. But it's a constant, delicate balancing act, isn't it?
It is indeed a constant balancing of religious freedom with societal order, public welfare, morality, health, and, critically, other fundamental rights. This inherent tension, this need to balance, is precisely why the courts have developed what's known as the essential religious practices doctrine.
Yes, you mentioned this. How does it work?
This doctrine is a judicial tool used to determine which practices are truly essential and integral to a religion and therefore constitutionally protected under Article 25 versus those practices that might be considered secular accretions, superstitious beliefs, or simply non-essential customs, which can be regulated or reformed by the state under Article 25 too.
But who decides what's essential? That sounds tricky.
It is very tricky. Ultimately, this determination is a matter for the courts to decide, often based on religious texts, historical practice, and expert testimony. It frequently leads to complex and contentious legal battles because what an individual or a group claims is essential might not align with what the core tenets of the religion, as interpreted by the court, actually mandate.
That's a subtle but really important point. It takes the interpretation beyond just individual assertion to a more, objective legal test, however difficult that might be. And the point about no coercive conversion is reinforced here, which seems crucial for a pluralistic society.
Absolutely crucial. The right to propagate is about sharing faith, not forcing it. Article 25 is foundational to India's unique brand of positive secularism, where the state maintains that principled distance treats all religions equally, does not establish a state religion, but can intervene for social good or reform without being inherently hostile to religion itself.
So it allows for state support for religious activities sometimes if done non-discriminatorily.
Yes, potentially, while also reserving the right to regulate secular aspects and push for social reform. It's a complex, dynamic model, very different from a strict wall of separation. Landmark case law.
Which landmark cases have truly defined these contours of individual religious freedom, particularly around that tricky essential practices doctrine?
Well, the Schurer-Mutt case, 1954, was foundational. It broadly defined religion beyond just belief to include practices considered integral. And it was the first major case to articulate this essential religious practices test, stating that religious denominations have the right to manage their own affairs in matters of religion and that the state could only regulate the secular aspects.
Okay, so that set the stage.
It did. Then, in Sardar Sayyidina Tahir Saifuddin Sahib versus State of Bombay, 1962, the Supreme Court upheld the practice of excommunication as an essential part of the religious practice of the Dawoodi Bohra faith, thus protecting their internal management in that specific matter from state interference. However, it's worth noting, as you might expect, that this ruling has been subject to later scrutiny and debate, particularly when viewed through the lens of individual rights versus community rights and social reform.
So not all practices are protected.
Definitely not. Conversely, in Durga Committee, Ajmer versus Syed Hussein Ali, 1961, the court held that superstitious practices or beliefs, even if associated with a religious place, are not necessarily essential and therefore not protected under Article 25. It emphasized that not every practice that happens in or around a religious institution qualifies for constitutional protection as a matter of religion.
And the propagation aspect, how did the court solidify that no coercive conversion principle?
That was clearly addressed in Reverend Stanislaus versus State of Madhya Pradesh, 1977. The court firmly affirmed that the right to propagate one's religion under Article 25 does not include the right to convert another person by means of force, fraud, or allurement. The court reasoned that forced or induced conversions actually impinge upon the other person's fundamental freedom of conscience, which is also protected by Article 25.
Makes sense. What about freedom of conscience itself?
The key case there is Bijo Emanuel versus State of Kerala, 1986, famously known as the National Anthem case. The Supreme Court upheld the right of 3 children belonging to the Jehovah's Witnesses faith not to sing the national anthem during the school assembly, based on their genuine conscientious religious belief that their faith only permitted prayer to Jehovah.
As long as they showed respect otherwise.
Exactly, as long as they stood respectfully during the anthem. This case powerfully highlighted the expansive nature of freedom of conscience, even when it might appear to clash with national symbols or sentiments.
And more recently, there was the Sabarimala case, right? That involved a lot of these issues.
Yes. The Indian Young Lawyers Association versus State of Kerala, 2019, the Sabarimala temple entry case, was a profoundly complex and highly debated case. It involved deep questions about essential religious practices, the scope of public order and morality as limitations, and the direct intersection or clash between the freedom of religion, Articles 25 and 26, and the fundamental right to equality for women, Article 14. The majority judgment ultimately affirmed the right of women of all ages to enter the temple, reasoning that the exclusion based on menstruation was discriminatory and not an essential religious practice. This case really highlights the ongoing, difficult judicial effort to balance these often conflicting fundamental rights within a rapidly evolving society. Legal maxims and theories.
Fascinating how the courts continually refine and interpret these fundamental rights in light of new challenges. What are the key legal maxims or doctrines that really underpin Article 25?
Well, the essential religious practices doctrine is clearly the primary judicial tool used here, the mechanism for delineating constitutionally protected religious practices from those secular or non-essential aspects that can be regulated by the state. And the broader concept of positive secularism is what describes India's distinct approach, allowing state intervention for social reform and ensuring equality among religions, while maintaining that principled distance from all faiths. It's a complex, continuously negotiated, and uniquely Indian framework. B. Article 26. Freedom to manage religious affairs. So while Article 25 focuses squarely on the individual's freedom of religion, Article 26 extends that freedom collectively. It grants autonomy to religious denominations, or sections of them, allowing them to manage their own internal affairs and institutions. It's really about protecting the institutional, the collective aspect of religious life.
Okay, so Article 26 is about group religious freedom, whereas 25 is primarily about you, the individual believer. What exactly qualifies as a religious denomination to get these rights? Are there specific criteria the courts look for?
Exactly. Article 26 is for the collective body. And yes, the courts have laid down specific criteria. To qualify as a religious denomination or any section thereof, a group must generally satisfy 3 conditions.
Which are?
First, it must be a collection of individuals who have a common system of beliefs or doctrines, which they regard as conducive to their spiritual well-being, essentially, a common faith. Second, it must have a common organization. And third, it must be designated by a distinctive name.
So a shared faith, an organization, and a name.
Broadly, yes. And just like Article 25, these collective rights granted under Article 26 are also explicitly subject to public order, morality, and health. Again, highlighting the balanced nature of these freedoms, ensuring they don't override basic societal norms.
And what specific, tangible rights are guaranteed to these denominations once they meet those criteria and operate within those limits?
They have 4 specific guaranteed rights under Article 26. First, Clause A gives them the right to establish and maintain institutions for religious and charitable purposes.
Like building temples or schools.
Exactly. Founding temples, mosques, churches, gurdwaras, monasteries, or even associated charitable institutions like schools or hospitals. For example, if a specific Christian sect establishes a church and a related charitable hospital, they have the right to do so and own the property associated with it under this clause.
Okay, what's the second right?
Second, Clause B, arguably the most crucial for autonomy, gives them the right to manage its own affairs in matters of religion. This grants autonomy over core doctrines, rituals, ceremonies, appointment of priests or religious leaders, basically, the internal essential religious practices of the denomination. The state generally cannot interfere here.
So the state can't dictate how worship is conducted?
Generally, no. For instance, a particular Hindu denomination's specific rituals for idol worship or the procedures for appointing priests within that denomination cannot normally be dictated by the state. These are considered matters of religion under Clause B.
Third right.
Third, Clause C, is the right to own and acquire movable and immovable property. This is essential for the sustenance and activities of any institution.
And fourth.
Fourth, Clause D, is the right to administer such property in accordance with law.
In accordance with law, that sounds like the crucial qualifier again. It links back to what you said about Article 25, too. The state can regulate secular aspects. So the distinction here is vital. The state can ensure proper administration of the property, but it cannot take away the fundamental right of administration from the denomination entirely. Is that right? The law must leave the administration with the denomination itself. That seems like a very important line to draw.
Absolutely. You've hit the nail on the head. This is a critical nuance and one that courts examine very frequently. The state can make laws to ensure proper administration of religious property, for example. Laws to prevent mismanagement, ensure proper accounts are audited, or prevent the diversion of funds for non-religious purposes. A state law requiring religious trusts to maintain properly audited accounts is perfectly valid under clause.
But they can't just take over.
Exactly. But if this state tried to completely take over, say, a temple's administration, replacing the denomination's management structure with government officials indefinitely, that could be challenged as violating both Clause B, managing its own affairs, and Clause D. The law regulating administration must not effectively extinguish the denomination's fundamental right to administer its property. The state can regulate, heavily if needed, but it generally cannot usurp the administration altogether.
Yes. So the analysis reveals this is really about granting collective freedom and autonomy to religious groups as entities, but always within boundaries linked to public welfare, good governance, and the law of the land.
Yes, precisely. It protects religious groups as distinct entities. And a key aspect, as we've discussed, is the judicial distinction often drawn between matters of religion, covered by clause, where the denomination's autonomy is high and state interference is minimal, and the administration of property under Clause D, where state regulation is permissible, provided it's for ensuring good governance and preventing abuses, and doesn't destroy the right itself. And that phrase, in accordance with law, is key.
It is. It means the regulating law itself must be valid. It must be within the state's legislative competence and not violate other fundamental rights. And as we said, it cannot extinguish the denomination's fundamental right to administer its property.
And Article 26 relates closely to 25.
Yes, they are often read together. Article 25 protects the individual's freedom of religion, while Article 26 protects the collective institutional freedom of the religious denomination. And of course, courts play a vital role in interpreting both, including defining what actually constitutes a religious denomination eligible for these Article 26 protections, ensuring genuine religious groups receive this constitutional shield, landmark case law.
Which landmark cases have really shaped our understanding of Article 26, especially regarding the autonomy of religious denominations versus state regulation?
Well, the Schurer-Mutt case, 1954, was foundational here too, just as it was for Article 25. It not only defined religion and essential practices, but also specifically delineated matters of religion under Article 26b, and laid down the characteristics of a religious denomination, setting the stage for understanding institutional autonomy.
And the tests for denomination status.
Later, in S.P. Middle versus Union of India, 1983, the court specifically applied and elaborated on the 3 tests for determining whether a group constitutes a religious denomination. In that case, it concluded that Auroville, based on the teachings of Sri Aurobindo and the Mother, while a spiritual community, did not satisfy all the conditions to be classified as a religious denomination under Article 26.
So it's not just any group claiming to be religious. There are clear legal requirements they have to meet to get Article 26 protection.
Exactly. It ensures genuine religious groups with established faiths, organizations, and names receive these specific constitutional protections regarding their internal affairs and property management.
What about the limits essential practices versus things the state can regulate?
A good example there is Acharya Jagadeeswarananda Avadhuta versus Commissioner of Police, 1983, known as the Ananda Marga case. The Supreme Court examined the claim by the Ananda Marga sect that performing the Tandava dance, allegedly involving carrying skulls and knives in public processions, was an essential religious practice for them. The court held that it was not an essential religious practice of the Ananda Marga faith and could therefore be restricted by the state on grounds of public order and morality. This again shows the essential religious practices doctrine being applied to a denomination under Article 26, clarifying that not all activities associated with a group are automatically protected.
And what about that crucial balance between the state's power over property administration and the denomination's right to manage its own assets? Any key cases there?
Yes, that crucial balance was significantly clarified and reinforced in Dr. Subramanian Swamy versus State of Tamil Nadu, 2014. The case involved a challenge to a government order that had appointed an executive officer, effectively superseding the hereditary trustee, the Podu Dikshitars, in administering the famous Natharaja temple in Chidambaram.
And the outcome?
The Supreme Court struck down the government order. It reaffirmed the denomination's right under Article 26D to administer its property in accordance with law. It held that while temporary state intervention or supersession might be permissible in cases of proven mismanagement, the state could not indefinitely usurp the denomination's fundamental right to administer its own property through such executive appointments. This decision strongly reinforced the delicate balance between necessary state oversight and the constitutionally guaranteed autonomy of religious denominations, legal maxims and theories.
The legal maxims or theories underpinning Article 26 seem to revolve quite clearly around the autonomy granted to religious groups and that ongoing effort to discern what truly constitutes a religious matter versus a secular, administrable one.
Precisely. The core principle is the autonomy of religious denominations. Article 26 provides the constitutional basis for their self-governance in religious matters, allowing them to preserve their distinct identity, doctrines, and practices. And alongside this runs the constant judicial effort to maintain the distinction between religious and secular spheres. Drawing this line, especially concerning property and financial administration, is critical for the practical application of India's unique secular framework, allowing for both religious freedom and necessary state regulation for public good. State neutrality and educational freedom. Articles 27 and 28.
So if the Constitution guarantees both individual freedom, Article 25, and collective freedom, Article 26, to practice and manage your religion, how does it ensure the state itself remains truly neutral? How does it stop the government from favoring one religion over another, particularly when it comes to using public money or running schools? That seems like the next logical step, and that's exactly what Articles 27 and 28 tackle, setting critical boundaries for state involvement in these sensitive areas. Article 27, freedom as a payment of taxes for promotion of any particular religion.
Exactly. Article 27 is a cornerstone of India's secularism. It's a direct manifestation of the state's commitment to neutrality in religious matters, specifically concerning finances. It explicitly prevents the state from using public funds, specifically funds raised through taxes, to promote or maintain any particular religion or religious denomination.
So the basic ingredient is clear. No person shall be compelled to pay any taxes, and the proceeds of those taxes cannot be specifically appropriated, meaning earmarked for the promotion or maintenance of any particular religion or religious denomination. That seems very straightforward. No using tax money to favor one religion.
That's the fundamental principle, yes. The object is to uphold the secular character of the state, preventing it from becoming partisan or acting as a patron for any specific faith using the public exchequer. Now, a crucial distinction, one that the judiciary has often examined, arises between what constitutes a tax and what constitutes a fee. This distinction has profound implications for you, the individual taxpayer, and for what the state can legitimately charge for.
Okay, let's break that down. What does this all mean for our listeners? The government can't force you to pay, say, a temple tax, specifically for building Hindu temples, or a mosque tax for mosques.
Correct. That would likely violate Article 27.
But they could potentially charge a festival fee for providing services during a religious festival. What's the practical difference for you as an individual taxpayer? And how do the courts actually distinguish between a tax and a fee in this context?
That's the heart of the matter. For you, the individual, a tax is generally understood as a compulsory exaction of money by a public authority for public purposes, enforceable by law, and not necessarily a payment for specific services rendered directly to you. It's part of the general revenue pool. So a hypothetical state temple tax levied on all citizens, with the funds exclusively earmarked for building new temples of one particular faith, or directly funding the propagation activities of a single religion, would almost certainly be a violation of Article 27. The link between your payment and any direct benefit you receive is diffused. It's for a general but religiously specific purpose.
Okay, that's a tax. What about a fee?
A fee, on the other hand, is generally considered a charge for specific services rendered or special benefits conferred by the state. A fee must have a reasonable correlation, a quid pro quo literally, something for something between the levy and the services provided. It's not usually merged into the general revenue. It's often earmarked to cover the cost of providing that specific service.
So an example of a permissible fee.
For instance, if the government charges a specific fee to a religious trust or organizers to cover the cost of providing special police arrangements, extra sanitation services, or traffic management during a large religious congregation or festival, that is likely permissible as a fee. Why? Because there's a direct service being provided to facilitate that specific religious event safely and smoothly. The state isn't promoting the religion itself, but providing regulatory or administrative services for its conduct. This distinction is vital in preventing indirect state promotion of a particular religion through subsidized services funded by general taxes. And the prohibition specifically mentions promotion or maintenance. This means the state cannot use general tax money to actively propagate a religion or for the preferential upkeep or establishment of the institutions of only one particular religion over others. It's about preventing the state from effectively acting as a financial patron for any specific faith.
Does this strict neutrality mean the state can't do anything at all for religious sites or structures, even if they have historical or cultural value? What about preserving ancient temples or mosques that are part of national heritage? Surely the state can help maintain those.
That's a crucial clarification, and you're right. Article 27 does not stop the state from making general welfare provisions or, importantly, from preserving national cultural heritage. If the government allocates funds for the restoration and maintenance of ancient religious sites, be they temples, mosques, churches, synagogues, or any other, as part of preserving national heritage, or due to their archaeological significance, that would likely not violate Article 27.
Why not?
Because the funds are allocated for a secular purpose, cultural or archaeological preservation for the benefit of the public at large, not for the religious propagation or preferential maintenance of a particular faith as a faith. The key is the primary intent and purpose behind the expenditure. Is it genuinely for a secular public good like heritage conservation, or is it aimed at promoting or maintaining one specific religion? Landmark case law.
So the underlying intent and purpose behind the spending matter a lot in the eyes of the law. What were some of the landmark cases that really solidified this distinction between a prohibited tax and a permissible fee in the context of Article 27?
Again, the Sherur-Mutt case, 1954, was pivotal here. It was one of the first cases to extensively discuss the difference between a tax and a fee, establishing that crucial quid pro quo principle. The court held that if a levy imposed by the state could be justified as a fee for services rendered, then Article 27 wouldn't be attracted, meaning it wouldn't be violated.
And this was applied in other cases?
Yes. This principle was reinforced shortly after in Mahant Sri Jagannath Ramanuj Das versus State of Vereda, 1954. This case examined the Orissa Hindu Religious Endowments Act, which levied an annual contribution on religious endowments to meet the expenses of the commissioner appointed under the act to administer them. The court affirmed that this annual contribution was essentially a fee, not a tax.
Why a fee?
Because there was a clear, ascertainable quid pro quo, the services provided by the commissioner and their office for the better administration and supervision of the religious endowments themselves. So it was a charge for services rendered to the institutions, not a general tax for promoting Hinduism.
Okay, that makes the distinction clearer. Now, I recall a more recent and perhaps more controversial case regarding government subsidies for religious pilgrimages, specifically the Hajj pilgrimage. That sparked significant debate about the interpretation of promotion of any particular religion under Article 27, didn't it?
That would be Praful Garadia versus Union of India, 2011. Yes, it was quite debated. In this case, the Supreme Court considered the constitutionality of subsidies provided by the Indian government for Muslims undertaking the Hajj pilgrimage. The petitioners argued that these subsidies, drawn from general tax revenues, violated Article 27 by effectively promoting a particular religion.
And what did the court decide? That seems like a direct challenge to the neutrality principle.
The court, however, held that the Hajj pilgrimage subsidies, even though paid from general tax revenues, did not violate Article 27.
That's quite a surprising interpretation for some.
Oh.
What was the court's reasoning there? How did they justify it against the text of Article 27?
The court reasoned primarily that Article 27 prohibits the levying of a specific tax for the promotion of a particular religion, not necessarily the spending from the general exchequer, for purposes that might benefit a religious community, especially if it's seen as facilitating a religious practice rather than promoting the religion itself. They noted that the funds came from the Consolidated Fund of India, which is funded by various taxes, not from a specific tax earmarked solely for Hajj. The court also observed, perhaps contentiously for some, that the government provides assistance or makes arrangements for other religious pilgrimages and festivals too, suggesting it wasn't exclusively favoring one. This ruling certainly raised important questions and continues to fuel debate about the precise interpretation of promotion or maintenance of any particular religion and the practical application of state secularism. Critics argue that significant general expenditure solely for one specific religious activity could still be seen as preferential promotion, regardless of the technical source of funds or whether it's labeled a tax. This case really highlights the ongoing complexities and debates in applying secular principles within a deeply religious and diverse society, where the state often interacts extensively with religious communities and their practices, legal maxims, and theories.
So, despite the complexities raised by cases like Goradia, the core legal maxims underpinning Article 27 seem clear. Secularism, particularly financial neutrality, and the quid pro quo principle distinguishing fees from taxes.
Exactly. Article 27 is a direct textual manifestation of the principle of secularism in the Indian context, aiming to ensure the financial neutrality of the state towards all religions. And the concept of quid pro quo remains the essential judicial test used to distinguish a permissible fee, linked to services, from a prohibited tax, a general levy potentially used for religious promotion in this specific context. It acts as a crucial filter for state financial interactions with religious bodies. B. Article 28. Freedom as to attendance at religious instruction or worship in educational institutions. Moving finally to Article 28, this provision ensures that state-funded or state-recognized education remains broadly secular and respects individual religious freedom, particularly the freedom of conscience of students within educational institutions connected to the state. It's a critical article that lays down a clear framework for how religion can, or more often cannot, be part of the formal curriculum or compulsory daily activities in different types of educational institutions. It cleverly categorizes these institutions into 4 distinct types, each with slightly different rules regarding religious instruction.
Okay, let's take them one by one. What's the first and perhaps most straightforward category? Institutions wholly maintained out of state funds, like a typical government school. What's the rule there?
For these institutions, Clause 1 of Article 28 states absolutely clearly, no religious instruction shall be provided. It's an unequivocal, complete prohibition.
No religious instruction at all.
None. So, for example, a government primary or secondary school, entirely funded by state money, cannot have mandatory daily prayers of a particular religion, nor can it teach specific religious doctrines as part of its regular compulsory curriculum. This is a strong, clear assertion of secularism in state-run education aimed at preventing indoctrination using public funds.
Okay, that's clear.
Yeah.
But what if a school has a religious history? Perhaps it was established centuries ago by a specific religious trust, maybe requiring religious teaching in its founding documents, but is now administered by the state. Does its historical intent still matter, or does the Clause 1 ban apply?
That's an excellent question, and it's specifically addressed by Clause 2. Clause 2 acts as an exception to Clause 1. It states that if an educational institution is administered by the state but was established under an endowment or trust, which requires that religious instruction shall be imparted in such institution, then the absolute prohibition of Clause 1 does not apply.
So religious instruction can be given in that specific case.
Yes, it can be imparted in such an institution, effectively respecting the original founder's intent and the specific terms of the endowment or trust deed, even if the state now manages the school's day-to-day administration. In such cases, the state acts more like a trustee, fulfilling the terms of the trust, rather than as a promoter of religion in its own right. So, for example, a school established by a historical religious trust that specifically required the teaching of certain scriptures can continue to do so, even if it now falls under state administration.
That seems like a pragmatic balance between secular administration and historical intent. Now, what about the other 2 categories? Schools that receive state recognition or maybe government aid, but aren't entirely state-run or bound by such historical religious endowments. What are the rules for them?
Clause 3 covers both of these categories. Institutions recognized by the state, even if they get no aid, and institutions receiving aid out of state funds, like private aided schools. For both these types of institutions, the rule is different again. Religious instruction may be permitted, but attendance at such religious instruction or participation in any religious worship conducted in the institution is purely voluntary.
Voluntary meaning.
It strictly requires the student's own consent, Or if the student is a minor, their guardian's explicit consent. No one can be compelled to attend.
So an example.
Okay, a private school may be run by a religious body that receives grant and aid from the state government. It might offer optional Bible classes or hold morning prayer meetings. Under Article 28.3, it absolutely cannot compel any student to attend those classes or prayers without their express consent or their guardian's consent if they're minors. This protects the individual student's religious freedom and freedom of conscience from compulsion, even in institutions that, while not fully state-run, benefit from state recognition or financial support. So in analyzing Article 28, the key themes seem to be maintaining the secular character of purely state education, respecting founders' intent where historically mandated, and absolutely ensuring voluntary participation in religious activities in aided or recognized private institutions.
Precisely. Clause 1 is that strong assertion of secularism in wholly state-funded education, preventing direct religious instruction funded by the public purse. Clause 2 provides a necessary balance, acknowledging historical contexts and respecting the specific purpose for which certain institutions were founded, as long as the state is merely administering according to the trust. And Clause 3 is all about protecting individual religious freedom, particularly the freedom of conscience, by making any participation in religious instruction or worship entirely voluntary in the vast majority of private schools that interact with the state system through recognition or aid.
Is there a distinction made between religious instruction and just teaching about religions?
Yes, that's a critical distinction courts have made. Religious instruction in the context of Article 28's prohibitions or requirement for consent generally means teaching the specific tenets, beliefs, and practices of a particular religion with the aim of inculcating faith or belief in the students. It's essentially instruction in religion.
And teaching about religion.
That's different. The academic study of religion, or comparative religion, or teaching about the history, philosophy, or cultural impact of various faiths, or even teaching universal moral and ethical values derived from different religious traditions, is generally not considered religious instruction in the prohibited sense. Such academic study is often seen as permissible, even desirable, as it's about imparting knowledge and understanding, not about indoctrination or compelling belief.
So Article 28 implicitly upholds the freedom not to receive religious instruction, too.
Absolutely. By making attendance voluntary in most cases where religious instruction might occur, and prohibiting it altogether in state institutions, the article inherently underlines and protects the individual's freedom of conscience to decline any religious instruction they do not wish to receive. It reinforces individual autonomy in matters of faith within the educational sphere, landmark case law.
Which landmark cases help clarify this crucial distinction between prohibited religious instruction, teaching in religion, and permissible academic study about religion?
DAV College, Jalandhar v. State of Punjab, 1971, was a key case here. The Supreme Court examined a university statute that made study of the life and teachings of Guru Nanak compulsory for certain students. The court held that the academic study of the life and teachings of a religious figure like Guru Nanak, when treated as part of history or philosophy, does not amount to religious instruction as prohibited by Article 28.1. It clarified that imparting religious knowledge in an academic, objective, non-dogmatic manner is distinct from seeking to inculcate faith or propagate specific religious tenets.
And this was reinforced later.
Yes, it was further reinforced in Aruna Roy v. Union of India, 2002. In this case, the Supreme Court upheld a national curriculum framework that included providing education about religions in schools. The court again distinguished this academic approach, learning about different religions, their core beliefs, and their contribution to culture, from imparting religious dogmas or requiring participation in rituals. It deemed the former permissible and potentially beneficial for fostering mutual understanding and tolerance in a diverse society, while the latter remained restricted by Article 28.
And what about minority institutions? They often have a distinct religious character and might receive state aid. How does Article 28 apply to them, given they also have rights under Article 30 to manage their institutions?
That's a relevant intersection. St. Xavier's College Society versus State of Gujarat, 1974, while primarily a landmark case concerning the rights of minority institutions to establish and administer educational institutions of their choice under Article 30, also touched upon their freedom to impart religious instruction, particularly to students of their own community. The court implicitly affirmed this right as part of managing their institutions.
But what about students from other communities, or the consent rule?
Crucially, the court also emphasized that if such a minority institution receives state aid, then the principle of consent under Article 28.4 still applies. No student attending such an institution can be compelled to take part in any religious instruction or attend any religious worship without their or their guardian's consent. This ensures that state funding provided to minority institutions doesn't become an indirect means of compelling religious participation among students who may not belong to that particular minority community. It balances the autonomy of minority institutions with the individual freedom of conscience of all students. Legal maxims and theories.
So wrapping up Article 28, the key legal maxims or theories seem to clearly revolve around secularism in education and the fundamental importance of freedom of conscience for students.
Indeed, Article 28 vividly reflects the principle of secularism in education, particularly in institutions wholly or partly supported by public funds. It does this by mandating neutrality in state schools and preventing religious indoctrination using state resources or authority. And Clause 3, with its emphasis on consent, particularly safeguards an individual students' freedom of conscience. It ensures that education aims to foster independent thought, understanding, and tolerance, rather than becoming a site for compelled belief or religious conformity.
Wow, what a journey that was. From the fundamental right to liberty and the detailed protections against arbitrary arrest in Article 22, navigating the complexities of preventive detention, then moving to safeguarding basic human dignity against exploitation in Articles 23 and 24, and finally, diving deep into the crucial freedoms of conscience and belief in Articles 25 and 26, all while intricately defining the state's secular role regarding finance and education in Articles 27 and 28. We've really covered a vast yet deeply interconnected landscape of constitutional protections in this deep dive.
Indeed, it's quite a sweep. These Articles 22 through 28, they're really more than just legal provisions written down decades ago. They represent the architectural framework, the very blueprint for a humane, just, and pluralistic society that the Constitution envisioned. They meticulously define the boundaries of state power over the individual and simultaneously affirm the inherent rights and dignity of every person. They are constantly trying to strike that delicate balance between personal freedom and collective welfare, between individual rights and societal needs.
They really underscore the aspiration, don't they?
They absolutely underscore the aspiration of India's constitution to build a society where liberty isn't just a theoretical concept, but a lived reality. And as we've seen, these rights are constantly being interpreted, debated, and expanded, particularly by a vigilant judiciary responding to the changing needs of society.
So for you, the learner, listening today, this deep dive hopefully provides not just knowledge about specific clauses, but a real appreciation for the intricate design of these fundamental rights and the dynamic, often challenging role of the courts in shaping them. It highlights how these foundational concepts, though sometimes contested and facing new challenges, are constantly being interpreted and upheld to protect the individual within a complex, diverse, and rapidly evolving society. Understanding these articles is, in many ways, understanding the very soul of India's constitutional commitment to its citizens.
And as we've seen throughout our discussion today, so many of these rights involve incredibly delicate ongoing balancing acts. That tension between individual liberty and state security in Article 22. The line between religious freedom and necessary social reform in Article 25. The balance between the state's regulatory power and a religious denomination's autonomy in Article 26. It makes you wonder, what are the biggest ongoing challenges in upholding these complex balances in today's world? Think about new technology, shifting social norms, heightened security concerns. How do these impact the application of principles written over 70 years ago? And perhaps more importantly, how does your deeper understanding of these constitutional principles empower you as an informed individual to engage with these complex questions, to critically discern where those balances might be shifting or being tested today, and maybe even to advocate for the principles you believe are most vital for a just society? Something perhaps to mull over until our next deep dive.